All right, we're going to go ahead and get started. If you haven't gotten food, you can sneak down here and grab some. Looks like we have plenty of food left over. I'm Ryan McIntosh. I'm the president of our Federalist Society here. And I'd like to first thank all the alumni for coming out. We like to see you guys get involved, and we appreciate being able to put on CLE credits for you. Professor Duncan is going to be our main speaker today. And how many speakers speaking to events did you do last year?
30.
So he did 30 events all across the nation last year. So we're very fortunate to have him here in our own school and be able to put this event on at no additional cost to us. And so most of you have either taken Professor Duncan, have him now, or will take him for either property or common law or one of his seminar or another class. So he's going to be speaking today on a new topic that he's only done in a couple other schools. And we're very fortunate also to have Professor Shavers here with us today, who this will be your second time this school year providing commentary for the event. So without further ado, we'll hand it over to Professor Duncan.
Yes, Virginia, I do own a tie. This is it. I just want to take a moment to mention the passing of John Gradwell. John Gradwell passed away on February 2nd, my dad's birthday, and John was a great friend, a great colleague. He was a legend here at the law school. He was one of those links that tie sort of the senior partners in some of the law firms with the junior associates and clerks, because he had been here for half a century. So I will miss him, we will all miss him, and I just wanted to make sure I mention that, because it's a big loss for us here in the College of Law community. I'm delighted to be here today on my home field at the College of Law to talk about Kermit Gosnell's murder trial, Roe versus Wade, and the masks of the law. Now, I have given this talk at other law schools, and I'll be taking it on the road to law schools all over the country in the next year or so. But this is the first time I'm using a PowerPoint with the talk. I'm being dragged kicking and screaming into the 21st century. And in my case, it was particularly difficult because I had to skip an entire century. And so I'm using this PowerPoint with the talk today. So this is kind of a moot court experience for me here. I'm mooting this in your presence. I think my research assistant did a great job putting some slides together for me for this talk, so I'm pretty excited about having the opportunity to try it out today. So thank you for coming on this winter day here with the roads being a little bit difficult. And please be patient with me if I slip over a slide or two. Well, let me just say at the outset, the topic is Kermit Gosnell and the mass of the law, sort of the fine line between abortion and infanticide is what this is about. It's a difficult topic, one that can be an emotional roller coaster. So I just want to say from the outset, my goal here is not to judge anyone or even to change your mind about abortion and Roe versus Wade. I just want to give you something to think about. And I've been on both sides of this issue. I was in law school, believe it or not. I was in law school when Roe was decided way back in 1973. Roe was decided in January of 1973, and I started law school at the Cornell Law School there in Little Ithaca, New York in August of 1973. And so it was the big case of my first year in law school. Everyone was talking about it, except apparently Justice Thomas. He didn't hear about it until he got nominated for the Supreme Court. But everybody else was talking about the case. We were very interested in it. And back in the day, I was actually a strong supporter of Roe versus Wade, and I was so strongly pro-choice at the time that my best friend in law school, who was pro-life, almost had to be restrained. He was so upset that I was taking the positions that I was taking in defending Roe versus Wade. So I've been on both sides of this issue. I have changed my mind over the years, and now I'm pro-life. But I wasn't a worse person when I was pro-choice, and I'm not a better person now because I'm pro-life. I'm the same person. I just thought about the issue for many years, and I've changed my mind. And I think we all need to keep thinking and talking about the abortion issue, because there's a lot at stake on both sides, and it's critically important that we get it right. So I call this talk Dr. Gosnell and the Mass of the Law. because it's about Gosnell's conviction for murder and how it gave the American public a peek behind the masks of the law concerning abortion. One of the great constitutional scholars of the past 50 years, professor at Notre Dame, I think at Hastings, and also a judge on the Ninth Circuit, Judge John T. Noonan of the Ninth Circuit, has observed that it is the propensity of professionals in the legal process to dehumanize by legal concepts those whom the law affects harshly. And he calls this process of dehumanization the masks of the law. And what Noonan meant by the masks of the law is the law's ability to use rules and legal concepts to conceal persons who are treated harshly by the law. He puts it this way: by masks in this context, I mean ways of classifying individual human beings so that their humanity is hidden and disavowed. So think about slavery in American legal history. Suppose the law wants to permit and even sanction slavery, as was the case in America before the Civil War. And the mask that the legal system used to disavow the human dignity of slaves was the mask of property. The mask of property was what allowed champions of liberty, such as George Wythe and Thomas Jefferson, to own slaves and to accept the power of the law to treat slaves harshly. For example, as a judge in the state of Virginia, George Wythe, a signer of the Declaration of Independence and its embrace of all men being created equal, was able to preside over the sale and inheritance of slaves, and to declare in one case that the property of slaves, whatever be their number, may be transferred with as little judicial ceremony as a single quadruped or article of house or kitchen furniture. As Noonan observes, Wythe could not have compassion for each of them as a person and still be a judge. At the critical moment, the masks of the law covered the faces of the slaves. Montesquieu, with biting irony, explained even more clearly the need for the masks of the law in an age of slavery. "It is impossible," said Montesquieu, "that we should suppose those people to be men. Because if we should suppose them to be men, we would begin to believe that we ourselves are not Christians." This mask of the law has a dual function. It hides the humanity of slaves, so judges in the law can treat them like an animal or an inanimate chair. And it allows the white ruling classes to think well of themselves by masking the tyranny of the system they enforce. We are not evil men, we are good men, lovers of liberty and equality, and protectors of private property in the pursuit of happiness. So do you see this point about the mask of the law and how they permit good men to commit grave injustices, good men like George Wythe, to commit grave injustices while still feeling good about themselves? So what does this have to do with abortion and Roe versus Wade and Dr. Gosnell's conviction and life sentence for infanticide? Well, it has to do with breaking the spell of the law's magic. What happens when the mask slips for a second and society gets to peek under the mask and see the person who has been concealed by the mask? What happens when Batman's mask slips and everyone sees Bruce Wayne's face underneath? The secret identity is destroyed and everyone now knows that Batman is Bruce Wayne. No longer the Dark Knight striking fear in the hearts of criminals. Just a billionaire playboy vigilante missing his mommy. There is no getting the toothpaste back in the tube once the spell is broken and the mask is removed. Great literature often reveals the masks of the law and helps the reader peek underneath the mask. For example, in Huckleberry Finn, Mark Twain writes about a steamboat explosion. Aunt Sally asks Huck if anyone was injured in the explosion, and he replies, "No," even though a slave had been killed. Aunt Polly replies, "That's a matter of good fortune that only a slave was lost, because sometimes people do get hurt." The reader, of course, is aware that Aunt Sally is looking at the mask of property, not the real human being who was killed in the explosion. Well, we don't read Mark Twain anymore. For those of you who prefer contemporary literature, consider Suzanne Collins' trilogy of the Hunger Games, in which a tyrannical central government, the capital, has essentially enslaved its citizens and forced them to live and work in vassal states called districts. Every year, each of the 13 districts, an interesting number, I think, must send 2 children as tributes to the Hunger Games, where they will serve as gladiators, fighting to the death for the amusement of the people of the capital, until only one tribute, the victor, is left alive. This is a kind of state-sanctioned, ritualistic murder of children, but no one is permitted to call it murder. The murder is masked as a popular reality game, the Hunger Games, and the tributes are masked as mere players in the game, mere pawns in the game. That is until Katniss, and I predict that there will be a lot of young baby girls named Katniss in the next 10 or 12 years. That is until Katniss, the teenage heroine of the novels, decides to rip off the masks of the law when her 12-year-old fellow tribute, little Rue, is violently killed in the games. Katniss mourns Rue as a murdered child, decorates her lifeless body in wildflowers, and explains her actions in these words: I want to do something right here, right now, to shame them, to make them accountable, to show the Capitol that whatever they do or force us to do, there is a part of every tribute they can't own. That Rue was more than a piece in their games, and so am I. Allowed to peek under the masks of the law, the reader sees clearly that each tribute is a person, a human being, a child, and that when the state requires these children to fight to the death in the Hunger Games, it is guilty of murder. Scholars of warfare also recognize the concept of masking the enemy and how physical distance makes it easier to kill. For example, in a book with the remarkable title, On Killing, a standard textbook studied, I am told, in the Marine Corps, Lieutenant Colonel Dave Grossman has a chart that demonstrates the spectrum of killing from up close and personal, for example, hand-to-hand combat, to maximum range by means of, for example, bombs or missiles or drones. Colonel Grossman demonstrates that the resistance to killing becomes increasingly more intense as we move from long-range killing to close-range killing. It is far easier for a bomber to kill an entire city of non-combatants with a bomb or missile than for a soldier to kill an enemy combatant with a bayonet or in hand-to-hand combat. For example, Colonel Grossman talks about how during World War II, bomber crews on both sides killed countless women, children, and other non-combatants in cities such as London, Hamburg, Tokyo, and Hiroshima. And he describes how they were able to do this without thinking of themselves as monsters. Remember Montesquieu. The pilots, navigators, bombardiers, and gunners in these aircraft, says Colonel Grossman, were able to bring themselves to kill these civilians primarily through application of the mental leverage provided to them by the distance factor. Intellectually, they understood the horror of what they were doing. Emotionally, the distance involved permitted them to deny it. From a distance, I can deny your humanity. And from a distance, I cannot hear your screams. It is emotionally traumatic to look into the eyes of another human being and drive a bayonet into his heart at close range, even when you know he's trying to do the same thing to you. It is much easier to push a button from thousands of feet above the ground and drop a bomb on a populated city, when all you can see are buildings and ant-like dots on the ground. The humanity of the women and children and other non-combatants living in the city being bombed is masked by distance. The bombardiers launch their bombs and missiles at targets, a mask, not at fellow human beings. So now let's talk about Roe versus Wade and the masks of the law in the jurisprudence of abortion. Of course, in Roe, the court created a fundamental constitutional right to abortion on demand throughout the 40 weeks of pregnancy. Whatever you think about judicial activism and how common or uncommon it is, Roe is the clearest example of judicial activism, of what Justice White called a raw exercise of judicial power. There's not even a hint of a right to abortion in the text and history of the written Constitution. As Professor John Hart Ely put it in an article published, it's called The Wages of Crying Wolf, one of the classic articles, published in the Yale Law Journal shortly after Roe was decided. The court's decision in Roe, says Professor Ely, who, by the way, supported abortion rights as a matter of legislation. The court's decision in Roe, says Professor Illey, is bad because it is bad constitutional law, or rather because it is not constitutional law and gives almost no sense of an obligation to try to be. In other words, Roe versus Wade is a decision in which the court judicially amended the Constitution to create a new constitutional right, and then deployed that judicial amendment to strike down the duly enacted abortion laws of all 50 states. So here's a way to think about Roe versus Wade and whether it's an activist decision by the Supreme Court. Think about this. Was there ever a time in American history when 3/4 of the states, 38 states, would have ratified a constitutional amendment proposing the abortion liberty as created by the court in Roe? That's what Article 5 requires. A legitimate constitutional amendment requires a 2/3 majority in both houses of Congress to propose the amendment, and then 3/4 of the states, 38 states, to ratify the amendment. So was there ever a time in American history when 3/4 of the states would have ratified the constitutional doctrine created by the court in Roe versus Wade? 1787, 1868, 1920, 1973 when Roe was decided, 2013, 2014 as the years keep ticking off. Ever? And if your answer is no, that you can't conceive of 38 states ratifying the doctrine of Roe versus Wade, which would be required to make it part of the Constitution if it was done through the normal amendment process. If you can't conceive of that, if your answer is no, never, that tells you something about Roe versus Wade and whether it is legitimate. On a scale of judicial activism of 1 to 10, in which 1 is the least and 10 is the most activist decision, Roe versus Wade is at 12. Be that as it may, well, I'm not here so much to debate Roe versus Wade, but rather to talk about the masks of the law created in that case, and how these masks conceal the human beings who are the subject of the abortion doctor's instruments. Of course, one of the major issues in Roe was whether the unborn child about to be aborted is a person under the protection of the Constitution, or even if it's not a constitutional person, at least a living human being whose life could be protected by state laws prohibiting abortion, what we might call a true Ninth Amendment right, the states acting to protect an important liberty, the liberty to life. So is the unborn child a living human baby, a living human being, a baby to use the common vernacular, or is it something else, only a potential life, or only a growth of human tissue? As Judge Noonan points out, prior to Roe, the common experience was to recognize the unborn human being as a baby. And that is still true to a great extent, even today, 41 years after Roe was decided. For example, when you learn that a friend or an acquaintance is pregnant, what do you ask her? How is your fetus? How is your product of conception? How is your potential human life? Or how is your baby? Well, maybe that is only because your friend is pleased with her pregnancy and that her unborn child is a wanted child, not an unwanted thing. Should that matter? Should the humanity of the unborn child depend upon whether it is wanted or unwanted? So a wanted child is a person, but an unwanted child is a thing that can be disposed of and thrown away. Well, in Roe, the Supreme Court was about to create a constitutional doctrine that would treat unborn children harshly. A doctrine that would forbid states from acting to protect innocent human life in the womb, but instead would allow the unborn to be aborted, to be killed chemically or surgically as part of the fundamental constitutional right of reproductive autonomy that the court was creating that day. To echo Montesquieu, the court had no choice but to cover the human face of the aborted children with the mass of the law in order to allow our society to feel good about itself, even as more than 1 million legal abortions are performed each year in post-Roe America. What the court did in the service of the abortion liberty in Roe was similar to what the legal system did in the service of slavery. Different issues, very different issues, but masks are the same. What the legal system did in the service of slavery during the days when slavery was legal. It masked the inhumanity of unborn children by denying them legal personhood or even any kind of actual existence. It's only a potential existence. It has no actual existence, said the court. The court held that an unborn child is only a potential life, not an actual human person or human being. As Noonan puts it, this move by the court was necessary because the court needed a legal mask to disguise the identity of the being who was aborted. If there were only two labels, says Noonan, one marked persons and one marked things, then if you were not a person, you must be a thing, and if you are a thing, your rights are nothing. And we don't have to feel bad about ourselves for allowing things to be destroyed by their owners. And so we have gone on our merry way since Roe was decided in 1973. And only a few of us ever stopped to think about how over 50 million babies have been legally aborted in the wake of Roe. And just to give you a yardstick by which to measure that number, 50 million, the population of California is about 38 million. And that is 12 million less than the number of state-sanctioned abortions. And I'm estimating low, it's probably closer to 55 million. But 38 million Californians, at least 12 million less than the number of state-sanctioned abortions that have taken place since Roe was decided. Or to put it another way, 50 million abortions are equal to more than 6 times the total population of New York City. You bet we need masks to cover the humanity of those 50 million aborted beings. If we should suppose them to be babies, what would we think of ourselves? What would we think of the court? And by the way, the humanity of the unborn is doubly masked. The law conceals the unborn child with the mask of potential life as opposed to actual human life. But notice that the unborn child is also physically masked by its presence in the womb. Pro-lifers used to say that if only there were a window that allowed us to see the developing baby in the womb, abortion would be over and the unborn would be protected. And well, we have that window today. It's called ultrasound. So let's talk about Dr. Gosnell and his little women's medical clinic of horrors. Irony of ironies. This is an actual graphic sign above the door to Gosnell's late-term abortion clinic. A happy daddy and a happy mommy walking hand in hand with their sweet little baby. That was the graphic over the door to his late-term abortion clinic. Well, as many of you are aware from following this story on the news, it was suppressed for a while, but finally it started getting covered. Even the New York Times finally covered it. Kermit Gosnell is a Philadelphia abortion doctor who was recently convicted of 3 counts of first-degree murder for killing 3 babies who were born alive during an abortion, only to be violently killed by the good doctor. He was also convicted of voluntary manslaughter for the death of a pregnant woman who had died as the result of a botched abortion procedure performed by Gosnell. He's currently serving life in prison. He was convicted of 3 counts of first-degree murder. He's currently serving life in prison. But he remains unrepentant. He says he is spiritually innocent and that his only crime was acting as, quote, a soldier in the war against poverty. So exactly what did Dr. Gosnell do to get himself convicted of first-degree murder? Well, my source for the facts in the Gosnell case, and I encourage you to Google this and read the grand jury report in its entirety. But my source is the report of the grand jury, written by R. Seth Williams, the Philadelphia district attorney. And here's a summary of Gosnell's crimes as reported by the grand jury. This case is about a doctor who killed babies and endangered women. What we mean is that he regularly and illegally delivered live, viable babies in the 3rd trimester of pregnancy, and then murdered these newborns by severing their spinal cords with scissors. Gosnell specialized in late-term abortions, abortions occurring after the 20th week of pregnancy. This is a lucrative market. He made a couple million a year. Because even doctors who perform abortions, and most don't, refused to perform late 2nd trimester and 3rd trimester abortions. Now here was his problem. He was not skillful enough to perform late-term surgical abortions without risking malpractice or harm to the pregnant woman, without perforating the pregnant woman's uterus. And because he lacked the skill to perform late-term abortions in the womb, his standard late-term procedure was to induce labor and then complete the abortion by killing the babies who were born alive. And again, here's how the grand jury described Gosnell's abortion technique. This is the grand jury report. When you perform late-term abortions by inducing labor, you get babies. Live, breathing, squirming babies. By 24 weeks, most babies born prematurely will survive if they receive appropriate medical care. But that was not what the Women's Medical Society was about. Gosnell had a simple solution for the unwanted babies he delivered. He killed them. He didn't call it that. He called it ensuring fetal demise, a mask. The way he ensured fetal demise was by sticking scissors into the back of the baby's neck and cutting the spinal cord. He called that snipping, another mask. That's, again, from the grand jury report. That's one of the victims of Gosnell's standard practice. An expert witness before the grand jury, a neonatologist, testified that the late-term baby feels a tremendous amount of pain when its spinal cord is severed. Here's one of the victims that he was convicted of killing. One of the babies that Gosnell murdered was estimated to be about 30 to 32 weeks gestational age when Dr. Gosnell severed his spine and put the baby in a plastic shoebox for disposal. The good doctor joked that this baby was so big he could walk me to the bus stop. Although he was only convicted of 3 counts of first-degree murder, there was testimony that snipping born-alive babies was Gosnell's standard late-term abortion procedure, and he probably was responsible for hundreds of born-alive killings. There was certainly some evidence of many examples of baby boy A. Well, I won't go into any more of the gruesome details. I encourage you to Google the grand jury report and read it in its entirety. It is eye-opening. It is horrifying to think that this could happen in this country. But what is significant about the Gosnell case is the nearly unanimous, all across the political spectrum, the nearly unanimous outrage and disgust for what he did, for Gosnell the baby killer. He is a modern Herod, guilty of killing hundreds of innocent babies who were born alive, only to be murdered as part of Gosnell's standard late-term abortion technique. But notice that the Supreme Court's abortion jurisprudence allows late-term, post-viability abortions, so long as the abortion advances the pregnant woman's health, including her physical, emotional, and even familial, whatever that means, well-being. Let me repeat that. Although the states have the theoretical power to prohibit abortions that take place after the point of fetal viability, both Roe and Casey and Doe versus Bolton, Roe's companion case, make clear that even after viability, abortion must be permitted, that there is a constitutional right to post-viability abortions, so long as the post-viability abortion serves the mother's physical, emotional, psychological, or familial well-being in appropriate medical judgment. And who's making that appropriate medical judgment? Kermit Gosnell, the abortion doctor. As Harvard law professor Mary Ann Glendon has observed, by defining health as well-being, the Supreme Court established a regime of abortion on demand for the entire 9 months of pregnancy. So Gosnell's crime was not killing these children. If he had been a more skilled doctor, he could have killed them in the womb, either surgically or chemically, and it would not have been murder. In fact, rather than murder, a late-term abortion in which the baby is killed while still in the womb, the exact same baby, is considered a fundamental constitutionally protected right. He's right. That's why he's saying, well, I can't understand why I'm in jail. I'm a soldier in the war against poverty. I'm serving fundamental constitutional rights. What am I doing in jail? The masks of the law determine whether it is murder or fundamental right. Kill the baby outside the womb, and it is murder, and Gosnell is a murderer. Kill the same baby inside the womb a few seconds earlier, and it is a constitutional right. And Dr. Gosnell is a hero, a champion of fundamental constitutional rights. In the womb, the unborn is only a potential life who may be aborted legally. It is just fetal demise, to use Gosnell's Orwellian language. However, if the exact same being is somehow born alive, just a few inches outside the womb instead of inside the womb, that being becomes a person, a baby, and when the doctor snips his neck, it is murder in the first degree. So what's in the name? Asked Shakespeare. Well, when it comes to the mass of the law, it is quite literally a matter of life or death. If the law conceals a person with the mask of property, that person can be bought and sold and treated as property, as a stick of furniture, and slavery is a lawful institution. But once the mask of property is removed, and we can see the enslaved person under the mask, slavery becomes a great evil, and we recognize as shameful the laws that refuse to recognize the humanity of slaves. When the law conceals a baby with the mask of potential life, that baby can be aborted, terminated, poisoned or dismembered or snipped, and we call it the constitutional right of reproductive choice. But if we peek under the mask, as we all did for a moment during the Gosnell trial, we see the baby literally staring us in the face, the little innocent human person, and we all agree that to take its life is to be guilty of murder, and we condemn Gosnell for what he did. As Judge Noonan has said, the masks of the law only work until the spell is broken and we can see the person underneath the mask. And I believe our nation got a peek under the legal masks of the abortion liberty as we followed the Gosnell trial in the news, which is why I think it might have been suppressed by some of the media. Well, some would say this is a lost cause. It's too late. Roe versus Wade was decided 41 years ago. It's just too late to overrule Roe versus Wade and its abortion manifesto. Because right or wrong, it is the law of the land, and it has become part of our legal landscape. It's a lost cause, Duncan. Well, that reminds me of something T.S. Eliot once wrote about lost causes. If we take the widest and wisest view of a cause, there is no such thing as a lost cause, because there is no such thing as a gained cause. We fight for lost causes because we know that our defeat and dismay may be the preface to our successor's victory, though that victory itself will be temporary. We fight rather to keep something alive than an expectation that anything will triumph. So let me just conclude with this. Let me just say again, I'm not here to judge anyone. I'm not here to persuade you to change your mind about Roe versus Wade or whether abortion should be legal or illegal. I want to ask you to do only one thing. Whenever the law creates a mask to conceal something or someone, I ask you only to peek beneath that mask and look carefully at the true nature of whatever or whoever is under that mask. When thinking about Roe versus Wade and abortion, look beyond the mask of the law and decide with your own eyes and your own hearts and your own minds about the reality of abortion and the subjects of abortion. Then decide what you think is right. But don't use the mask of the law to conceal what is real. Thank you all for coming out on this winter day, and I look forward to hearing Professor Schaefer's comments.
I must say, first of all, that I was a little reluctant to do this because you had heard me once before commenting on another speaker, but I was told that search as hard as they couldn't find someone that was willing to confront Professor Duncan. So I thought I would agree to that. So first of all, as you might imagine, I agree with a lot of what Professor Duncan said about masking behind the concept of lack of personhood. Also, you know, he personalizes a little, so let me personalize this too. I'm a person that considers myself both pro-life and pro-choice. And you say, well, how could that possibly be? Those are usually two antagonizing positions. Well, I think many people who would profess to be pro-choice, as I do, believe that the best option in a perfect world is for a woman to proceed with her pregnancy and welcome the birth of a child. But that's always not the best choice for that woman. It's not always the best solution, and this is not a perfect world. So Professor Duncan left you with this concept of removing the mask. What I would like to ask you to add to that inquiry is to do what many feminists and what I do when I'm scrutinizing any law or legal concept, is ask the woman question. The woman question is, how does this principle, this law, this legal concept affect women? Does it impose a burden upon women or deny a freedom to women that is enjoyed by men? For many decades in our history, women were not considered a person, as Professor Duncan highlighted, for many legal concepts in our history. So lingering in this issue of choice still remains, who is the person? Is it the woman who has had choice removed, or do we consider that the fetus has superior rights to the woman? The interests and rights of women much throughout our history were given very little weight. Women were often regarded as the property of their fathers or husbands rather than as autonomous persons. Women could rarely refuse to have sex with their husbands or to bear children. Single women who became pregnant due to rape or were too poor to raise children were unable on those grounds alone to obtain approval from most religious authorities for abortions, and vestiges of this remain today. Just as during my lifetime, vestiges of slavery, one type of mass that's removed, remained in the forms of segregation and separate but equal schools. Today, many of these violations of women's rights we would find not acceptable. The denial of the dignity and well-being of women. Even many people who disapprove of abortions, nonetheless, support the legal right of women to obtain them. And that's one reason I might consider myself pro-life and pro-choice. I would advocate pro-life when possible, but leave the choice to the woman that is involved. Especially when the consequences for women when abortion is illegal are often deadly. They may be deadly in the form that the woman may lose her life by seeking abortions that are not allowed under the law. Women may suffer stigma, shame, and economic consequences from being pregnant that are not shared by men. So in asking the woman question, does this impose a burden upon women that is not imposed upon men? I think the answer would have to be yes. If you also trace back in the history, both non-religious as well as religious, often the choice has been who has the moral status of a person when you're choosing between a child, an unborn child, and a woman. And in many situations, the unborn child has not received the moral status of a person that the woman has received. In reaching this decision, removing the mask, and asking the woman question together, we must focus on the equality principles that must apply to women, the reproductive health that must apply to women, and the self-determination that should be rested with the women. One last thing I'd like to have you think about is, in respect to the example that Professor
Finally!
Professor Duncan gave regarding the whether or not we would say that 38 states would ever vote for upholding Roe versus Wade. Some of you can remember in your lifetime, maybe not many of you in this room, but during your lifetime there was a thing called the Equal Rights Amendment, which we never could get enough states to vote for. When you have a majority failing to vote for a civil rights principle, a principle of equality, does that mean it's the right thing to do? So I would say just by not having states, a majority of people in states vote for a principle does not mean it is a principle that it is invalid and should be accorded. So again, I leave you with this one suggestion, is ask the woman question.
What do we got?
Yeah, we have
Good.
time for question and answer. Yes.
I wanted to get your opinion on what you think about people putting on masks because of facts. And I think that when I listened to your speech, I kept on thinking, in addition to abortion, about the issue of the death penalty. And it seems like many people that advocate for what you're doing here, pulling back the mask, will then put on the mask when it comes to the death penalty under the using facts of the case to justify putting on that mask. And so I'm just wondering if that's the thing that
Well, I'm personally opposed to capital punishment as a matter of what the legislature should do. I don't think it's unconstitutional for reasons having to do with original understanding. But I'm personally opposed to. So if I were a legislator in the legislature, or if I were president of the United States, I would certainly come out politically against the death penalty. But I think you're right. There are people who are able to kind of either see life in the womb but not see it in the prisons or whatever. But I'm a big prison reformer. I think we have to do a lot of things to make the prisons better and more humane places than they are. And so personally, that's not a problem for me. But I think you're right. There may be somebody who is inconsistent. They see life and want to protect life in one place, but not in another place. I'm not Catholic, but I know that's what the Catholic Church calls the seamless web, that you should protect life wherever it is, and that would include capital punishment for lying about Catholics. So, good question.
Thank you.
Anna, do you have something to add to that? Yes.
So you both sort of alluded to religion or religious organizations' role in this whole issue, this whole debate. But you both kind of made arguments that seem to me primarily not to focus on that, right? Not to focus on morality.
Yeah.
Yet when we've had some of the contraceptive mandate cases
Right.
you referred to come down, they've judicially defined abortifacient as a religious term. So I think they we get mixed up in this whole debate
Yeah.
as to what is or is not religious.
Well, I don't
Do you
think
see this
anyone is.
abortion issue
Go ahead, I'm
as a
sorry.
religious one?
I don't think anyone's defined abortifacient as a religious term. I think some people have religious objections to abortifacients, and other people may have no objections or secular objections, and then for purposes of free exercise, the only thing that's protected under the free exercise clause is sincerely held religious beliefs. So if you have sincerely held religious objections to the contraceptive mandate, you're at least have an argument under the free exercise clause or under RFRA. If you have a secular objection to abortifacients, then you don't have a religious freedom claim. You might have some moral claim, but you wouldn't have a successful First Amendment claim. So to me, it's not a religious issue. To me, a lot of what I talked about today is Roe good constitutional law? It's not even is abortion good policy, good public policy. The question is it in the Constitution? Is it appropriate for the court to take this issue away from all 50 states and to create a very extreme constitutional right, a constitutional right that would go all the way to the point of Gosnell. 1 second it's permitted, 1 second later it's not, and that's because the reason it's that extreme is because Roe versus Wade is literally that extreme. Whereas if we kick the issue back to the political process, whether it be Congress coming up with a national law of abortion for us or the individual states, we'd be able to take into account all of the moral considerations. We could look at the women's question. We could look behind the mask of the law. The legislatures could kind of evaluate all of these issues. And we'd probably come up with something that wasn't as extreme as Roe, but my guess is abortion, Roe versus Wade gets overruled tomorrow. Abortion will still be legal. In many states, maybe even Congress would do something. But I doubt if we'd have that extreme version of the abortion liberty that I think Roe has created and has imposed on the political process. Okay. Lots of places in Europe, abortion is legal before some point 18. I think I was just reading today. Is it Denmark or I can't remember. But it's legal before 18 weeks, but it's not permitted after 18 weeks. That's kind of a legislative compromise. As the fetus develops, it takes on more human characteristics, and at some point maybe the legislative process is this far and no further. The court tends to declare a right, and then the right occupies the whole field.
I'm just going to add something else extreme about asking a woman question, which I think is one reason you find some feminists with mixed feelings about this whole situation is, in some parts of the world, since you mentioned Europe and other parts of the world, the use of abortion and infanticide is focused primarily on girl babies. So they've taken this modern convenience of ultrasound to examine a woman during her pregnancy to determine whether or not she is carrying a male child or a girl child. And girl children are not valued as much, primarily because women, are not worth as much because of the rights they're denied. So it's all tied up with whether or not people recognize the worth of women. And so many people are using abortions in that situation, and infanticide for that matter, to get rid of girl babies. And now there's sort of a lopsided population in some of these places because of the number of girl babies. So you can see that depending upon the situation you're in, your location, you can find arguments to be against abortion, for example, or the right to abortion. But I think in each situation you can look behind the motivation for why you're having these laws and restrictions.
Yes?
You talked about the relative age of the fetus and technology. How much different are we in technology from 1973 to today? And how likely is it that our current Supreme Court would revisit the case to talk about late-term abortions? Maybe they've done that recently, but is that likely to get further ruling from the Supreme Court?
Well, a couple of things. One is Roe versus Wade was decided basically in a world without ultrasound. I think the technology was theoretically available, but it was decided in a world where ultrasound. And now, pregnant couples who are excited about their children, the baby pictures, the videos, the home videos begin early in the pregnancy when they go to some ultrasound guy who does a DVD for them so they can document and put up on Facebook the entire journey of little Johnny or little Susie. And so it's becoming more and more common. That may be part of the reason. I don't know. The abortion rate has declined. You probably saw this in the media. We're down from about 1.5 million to just a little bit over 1 million abortions a year. And maybe part of that, part of it may be better birth control, but part of it may be that people are becoming more and more aware of, they're looking beyond the mass of the womb because ultrasound has become so common in our society. A lot of states are trying to legislate an ultrasound requirement before an abortion can be had. And again, that's part of it is designed to look behind the mass of the law. In terms of what the Supreme Court would do, well, Justice Kennedy is still the fifth vote. And Justice Kennedy was part of the KC5, the troika, but with two other justices. So I don't know, it's not a lost cause. But so much depends on personnel. When the Supreme Court's making up the Constitution as it goes along, then personnel is what matters. And, Justice Brennan talk about the rule of five. Me and four robed buddies can do anything we want to do. And I don't think the votes are there. So, the votes might have been there at the time. In fact, Kennedy switched. Kennedy, everything we know is that Kennedy originally voted to overrule Roe versus Wade, and there was a 5-justice majority to overrule Roe versus Wade in the Casey case, and then Kennedy flipped and came up with kind of a compromise. We'll reaffirm Roe, but we'll permit more regulations. And we've been living with that compromise for a long time, but that compromise allows a lot of this kind of ultrasound laws and regulations, informed consent laws. The 20-week law is probably unconstitutional under Casey, but maybe they'll take another look at that. Maybe Kennedy will move another degree or two over if that Texas law comes before the court. So, yeah, I don't know. Okay. All right, well, thanks for coming. I know it was a tough day to travel.